Good afternoon and welcome everyone to this discussion of women in the Supreme Court Bar. I'm Mitt Regan, professor here at Georgetown and co-director of our Center for the Study of the Legal Profession. Our center is co-sponsoring this event with the Georgetown Law Supreme Court Institute and the Women's Legal Alliance. I'm here simply to introduce our moderator for this discussion, my colleague Pamela Harris, who is executive director of the Supreme Court Institute. Until last year, Pam was partner and then of counsel at O'Melveny & Myers, where she was a member of the Supreme Court and Appellate Practice Group. She's also worked at the Office of Legal Counsel in the Department of Justice and has taught at Harvard and the University of Pennsylvania Law Schools. Pam served as law clerk to Justice John Paul Stevens and to Judge Harry Edwards on the Court of Appeals for the D.C. Circuit. And with that, I'll turn the proceedings over to Pam.
Welcome, and thank you all for joining us today. Thanks are on behalf of the Supreme Court Institute and also the Center for the Study of the Legal Profession and the Women's Legal Alliance. We are so honored to have with us today four truly distinguished panelists. I'm going to introduce them only briefly because in just a minute each of them will talk to you a little bit about their careers and their work as Supreme Court advocates. So I'm just going to indulge in a little bragging because this is really a remarkable group of panelists. We are truly honored to have with us Justice Ruth Ginsburg. Justice Ginsburg, as you probably know, is an Associate Justice on the United States Supreme Court. She was appointed in 1993 by President Clinton. Before that, she was a judge on the D.C. Circuit. And before becoming a judge, Justice Ginsburg was herself a leading Supreme Court advocate. Working with the ACLU Women's Rights Project, which she co-founded, Justice Ginsburg briefed and argued several truly groundbreaking women's rights cases before the Supreme Court in the 1970s. During that time, she won a reputation, a well-deserved reputation as a first-rate advocate and legal strategist, and she really is among the small handful of Supreme Court litigators for whom it can be said she changed law. She pushed the law in a new direction. So we are just very privileged to have her with us today, who can speak about, because she can speak about women in the Supreme Court bar from both sides of the bench, bring a perspective from both sides. We're also joined today by Professor Karlan of Stanford Law School, where she is a Kenneth and Harold Montgomery Professor of Public Interest Law and also a founding director of the Stanford Supreme Court Litigation Clinic. Pam is a leading example of a distinct breed of Supreme Court litigator, someone who combines a very successful academic career with a very, very active Supreme Court practice. And indeed, just this morning, Professor Karlan was with the Supreme Court Institute leading a case that she will argue this session before the Supreme Court, Karlan versus United States. Next, we have Patty Millett, who is at Akin Gump, where she is a partner and co-head of the Supreme Court practice. Before joining Akin, Patty was many years, most recently in the Solicitor General's office, the Office of Department of Justice that represents the United States before the Supreme Court, and before that in the Civil Appellate Division. Now, Patty has argued cases, 28, is that still current? 28 cases before the Supreme Court, including 2 cases just this term, which makes her one of the most experienced law advocates practicing today, certainly one of the most experienced women law advocates practicing before the Supreme Court. Finally, we have Virginia Seitz, a partner at Sidley, Austin, and a senior member of what was the private bar's first real Supreme Court and appellate practice. Virginia has been a leading member of the Supreme Court bar for over 20 years, countless accomplishments to her name, and I'm only one, which is that Virginia is the author of the famous military brief in the Grutter and Grass affirmative action cases, which is an amicus brief filed on behalf of military officers, arguing for the importance of diversity in the military. It was discussed extensively by the court in oral arguments cited in the court's opinion, and widely thought to be one of, if not the most influential amicus brief in recent years. All right, our panelists all have somewhat different backgrounds, but what they have in common is that they are all members of the Supreme Court bar. And I'm using that term not as a formal designation, but to describe a small group of Supreme Court experts that now dominate Supreme Court practice. Lawyers who specialize in Supreme Court advocacy and practice regularly before the court, both as brief writers and as oralists. And the emergence of this specialized Supreme Court bar is a relatively new development. For many years, we really didn't have repeat players before the Supreme Court With the exception of the Solicitor General's office and some public interest groups, that usually as lawyers who happen to have a case granted and found themselves in front of the Supreme Court for one time. Over the last 20 years or so, there's been a real change in the way Supreme Court practice is structured. And we've seen a small group of experts, many in private firms, again, starting with Sidley turning Supreme Court advocacy into a much more specialized and elite practice, with the same group of Supreme Court veterans, many of them former Supreme Court clerks or former Solicitor General lawyers or both, but the same group of lawyers briefing and arguing more and more of the Supreme Court's cases. This specialization of Supreme Court practice, I think, raises a number of very interesting questions, many of which are being addressed by Georgetown's own Richard Lazarus, the leading academic in this area. But the one we want to focus on today is the question of gender diversity in the Supreme Court bar. Because with some notable exceptions, it's fair to say that this prestigious bar has been mostly comprised of men, and that women, along with people of color, I should note, have been underrepresented. And you can see this in the numbers, and there's a recent study out showing that the percentage of women advocates before the court has been hovering in the 12 to 15% range for most of this decade. And I will say that I saw that study, and I wasn't going to cite it today because it didn't sound right to me. I thought those numbers were too low. So I went through this afternoon, just, the crosshatch method, counting up the advocates who had appeared before the court this term. And so far this term, we've seen 143 male oralists before the court and 31 female oralists, which is right at around 16%. So these numbers do seem to be holding up. If you prefer your evidence anecdotal, I will point you to a Washingtonian magazine article that came out earlier this year when Maureen Mahoney, a prominent Supreme Court advocate, announced that she would be stepping back her practice somewhat. And the article wondered what this would mean for women before the Supreme Court because there were so few of them. I think we can assume that if, say, Ted Olson were to decide to cut back on his practice, one thing the articles will not wonder is whether there's a future for men arguing before the Supreme Court. So there's an issue here. I think it is fair to say that there's an issue. And that's what our panelists will be talking about today. Where women are today in the Supreme Court bar and why, whether there's cause for optimism about the future, and how women law students who are interested in a Supreme Court or appellate practice should be thinking about and preparing for that career. All right, with that introduction, I will get out of the way and turn this over to our panelists. And we will reserve time at the end of today's program for questions from the audience, because we would very much like for you to participate in this conversation as well. I'm going to start by asking our panelists to talk just for a few minutes about their own work as Supreme Court advocates and how their careers brought them to a point where they were arguing before the Supreme Court. And as I think you'll see, there have been some different paths taken to this point in the career. Justice Ginsburg, would you like to start?
The first case I briefed for the Supreme Court was in the year 1971, and it was the case of a woman named Sally Reed, whose son, a teenager, had died tragically. Sally wanted to be administrator of his estate. Her former husband applied for the same position. The probate court judge said, "The Idaho law decides this question for me." It reads, "As between persons equally entitled to administer a decedent's estate, males must be preferred to females." A colleague of mine at the ACLU, he was then one of the general counsel, a marvelous lawyer named Marvin Kropotkin, noticed this case in Law Week. And he said, that is going to be the turning point gender discrimination case, because until then, the Supreme Court had never seen a differential between men and women that it didn't like. And so I was, in those days, mostly a teacher. I was at Rutgers Law School, and I agreed with Marvin Kropotkin, and I said, I would love to write that brief. the then legal director said, we will write the brief, which we did. And that was the beginning of my decade arguing cases before the Supreme Court. Now, one doesn't get there automatically, as you know. The case has to start someplace else. And one thing I'd be curious to hear the response of my panelists. I don't know anyone who has exclusively an appellate practice before the U.S. Supreme Court. I think most of them appear before other appellate courts. But when you recited the statistics that you did, dispiriting as they may be to people the age of most of you in the audience, for me, they are exhilarating because women simply were not there. And Patty may know, who was the first woman hired at the SG's office and what year it was?
Harriet Shapiro, and I don't know the year. It was Erwin Griswold when he was Solicitor General that hired her.
And Harriet was married, her husband was also in the SG's office. She was the only one. Women came, if at all, as one-at-a-time curiosities. And I'm pleased to say that the last place where women were not there in the Supreme Court has ended. The Supreme Court last year appointed its first woman special master in a case between two states. So now there are no more closed positions. And I think it's time for me to ask my neighbor for her response.
Well, I went to law school because I wanted to be a civil rights lawyer, and I think unlike anybody else on the panel, the first two cases that I argued at the Supreme Court were both cases where I actually filed the complaint. Because I was a civil rights lawyer at the NAACP Legal Defense Fund, and I filed one of them as a voting rights case at the Legal Defense Fund, and the other one actually came after I had gone into teaching when a student raised his hand in class and he had a problem and came to me after class and we discussed the problem, and he said, well, what can I do about it? I said, well, you could file a lawsuit. And he said, would you file it for me? And I said, sure. And I went to the professor in the next office over and said, I need local counsel because I wasn't admitted in Virginia. And so we filed a complaint on his behalf, and that went to the Supreme Court. So that, it's sort of like, how do you get to the top of an oak tree, sit on an acorn, and wait for it to grow? And so that was how my practice started. It started as a civil rights practice in which some of the work was appellate work, and I think we'll get into this a little more later as well. But I found I liked appellate work much better than I liked trial work because I disliked intensely the interpersonal conflict of the pre-trial phase. And one of the great things about appellate work is everything comes to you in a box, and there are very few opportunities for real interpersonal conflict and tension relative to litigating in the trial courts. So that was the start of my practice. And then when I was in teaching, I did a number of amicus briefs on a variety of different issues, mostly, again, civil rights-related issues. And then a friend of mine, Tommy Goldstein, who's sitting in the audience here, it was sort of like one of those old Judy Garland, Mickey Rooney movies, said, I have a Supreme Court practice, let's build a clinic. And so we started a clinic, and we now run a Supreme Court clinic that has, I think this year we had 8 merits arguments at the Supreme Court by lawyers affiliated with the clinic, and we've kind of had a steady state of about that number over the last couple of years, because it turns out if you're willing to work for free, there are many more clients to be had. And luckily we have day jobs that enable us to do it. So that's how I kind of started my practice. And then after you've done a couple of cases, more cases come to you. And so a number of the cases, for example, the case I'm going to be arguing later this month, came to us. Somebody who had seen our work in the past and had a case and thought we might be able to help in getting certiorari granted and then in briefing and arguing the case.
Well, first of all, thank you, Pam, for putting the panel together and for inviting me. My career is probably more typical of the route that women have taken to having significant opportunities before the Supreme Court, although it is still a more recent innovation, and that is through the government. I started as couple years I'll leave out for brevity's sake, but started my appellate career in the Justice Department in the Civil Division's appellate staff. And so started arguing around courts of appeals around the country and started working on some Supreme Court merits cases. And then when Drew Days became Solicitor General, he actually, I give him a lot of credit, diversified the sources of hiring within the Solicitor General's office. And it's not uniform, but predominantly prior to that, there had been hiring from appellate practices in law firms in Washington, D.C., people who were recommended by former members of the Solicitor General's office. Well, notwithstanding the hiring of Harriet Shapiro, one can imagine that statistically the number of people in law firms practicing in appellate practices recommending people was predominantly former males who'd been in this, or still males, not for real. That's a whole other panel. Former deputies in the Solicitor General's office who then they were males and were recommending people, and there really had become quite an established pipeline. And I give Drew Days, who was President Clinton's first Solicitor General, enormous credit for breaking from that. I'm very biased in this, and starting to look for other sources, including within the Justice Department, where you have people who are very experienced arguing appeals cases and writing appellate briefs. And so he hired me from, although it's kind of a sad story, he hired me and then promptly left the building. So he didn't actually want to work with me, but he left, and then I worked for Walter Dellinger as Solicitor General in his first year. And then I was in the Solicitor General's office for 11 years, which gave me obviously enormous opportunity to argue cases before the Supreme Court. And I think if you look at the statistics that Professor Harris was talking about, you will see that even to the extent there are women appearing in the Supreme Court, predominantly, not exclusively, but predominantly they are there because they are representing a government or governmental entity. And so the question is, I think for future gestation on this panel, is how often statistically are women arguing for cases where they're not representing a government or they're not arguing for free? Can you actually make, and this is now what I'm trying to do, I'm now at a law firm with Tom Goldstein at Akin, Gump, trying to actually make a living arguing cases in the Supreme Court, and yes, Justice Ginsburg, in the courts of appeals, because you don't grant enough certiorari in cases for us to do it in the Supreme Court.
Well, I think my appellate career began when I came out of the birth canal, because my father was a Third Circuit judge at the time, and for many, many years the Chief Judge of the Third Circuit Court of Appeals, and I grew up in a household where the Weekly League poker game was Third Circuit judges, and life around the dinner table was, one judge after another from either Delaware or the Third Circuit. So, and law clerks. Law clerks were my babysitters. And my brother's babysitters. And so I always knew I wanted to grow up and be a law clerk for a judge. And I was very proud of my father, who had been the judge who desegregated the Delaware schools and was the only judge upheld in Brown versus Board of Education. And so I aspired to be a lawyer, and I aspired to be an appellate lawyer early on. I then went to Buffalo Law School because I happened to be teaching in Buffalo, New York, and I had the good fortune to have a professor who was connected with Harry Edwards. He recommended me to Harry Edwards, and I had an appellate clerkship, and then went on to clerk for Justice Brennan. I think one ingredient of an appellate practice, if you want to have one, is clerking for a judge. And so I'm a sort of typical example of that. Then I went to a small union-side labor firm called Bredhoff and Kaiser. And the virtue of doing that, instead of going immediately to a large firm, is that when you have a case, it's your case. And so within 3 months after I was there, I was arguing a case in the Maryland Supreme Court. And if you filed a complaint, you worked on the case all the way through, even up to the Supreme Court. And so writing briefs, we represented a good piece of the labor movement, and were outside counsel for the AFL-CIO and the steelworkers. So we had a lot of Supreme Court cases. Until this year, however, the preeminent woman partner at Bredhoff, Julia Penny Clark, I don't think had argued a Supreme Court case, so she'd argued a lot of appellate cases. Those cases tended to be predominantly argued by the males at Bredhoff. And I was about to be a colleague of Patty's at the Solicitor General's office when my infant son came down with meningitis. And I decided I couldn't afford to change my life too much for that next year and a half, so I didn't go to the SG's office, and I instead became a partner at Sidley Austin. And I would say, it is much harder, as Patty's saying, without that government experience to have a Supreme Court practice. I'm fortunate that Sidley has, a significant number of cases in the Supreme Court every year to work on. But I would use my career as a good illustration of, if you really want to do it and do it in a typical way, you should get that government experience instead of doing what I did and staying in private practice.
I just want to have a minute, please. Yes. I can't resist saying what super lawyers we have on this panel, because every time Pamela Karlan or Patty Millett is up at bat, I know that we're going to get a super brief and an excellent appellate argument. And then Virginia Seitz, if there was a brief that made a real difference, that brief on behalf of the military leaders, the leaders of the military academy, it grabbed everyone's attention, and it ought to be given as a model for how a brief should be written. It wasn't very long, but it was, it was just powerful.
It's an amazing brief. I had just one question about sort of people's careers and how they ended up doing the kind of practice they do. Virginia, you mentioned that you had the good fortune to have a professor who knew Judge Edwards and talked to you about that. I mean, I feel that my career was largely shaped by the good fortune that I had a professor who, when I was sort of wandering around law school saying, I hope I can find a job in a law firm somewhere, said, okay, here's what you do. The first thing you do is you get some good credentials in law school, and then you clerk, and here's what's going to happen, and I'm going to do it, and I'm going to work with you, and I'm going to make this happen because I think you're really great. And if he hadn't said, and it was a male professor, and if he had not said that to me, none of that would have occurred to me. And so I think that sort of great good fortune was a big part of my career, and I'm wondering if any of the others of you had sort of that kind of a mentor at some early stage in your career who helped to make this happen, or at least helped to make you think that it could happen.
It was certainly true in my case. I was at Columbia Law School for my third year. I'd been at Harvard for the first two, transferred to Columbia, and applied for law firm jobs, clerkship jobs, and I got 0 responses. So a great teacher of constitutional law, Jerry Gunther, who was in charge of getting clerkships for Columbia students, took me on as his cause. He called, I think, every judge in the Second Circuit, on the appeals court and the district court. And then finally he came to one who always took law clerks from Columbia and said, I have an excellent candidate for you. And the judge responded, Professor Gunther, she has a 4-year-old child. So not only was I a woman, but I was a mother, and that put me just out of the box. The deal was that the judge would take a chance on me, but if I failed, there was a young man in my class who was going to work for a downtown firm who would be ready to take over. Professor Gunther never told me that. So I thought that the judge hired me because he had 3 children, 2 girls, and he wanted his girls to have opportunities to make their way in the world without encountering discrimination. But where would I have been without that first job? Justice O'Connor has a similar story. She was very high in her class at Stanford Law School. She could not get any job, so she volunteered to work, I think it was for the LA County Attorney, worked for free for 4 months, and said, at the end of that time, if you think I'm worth it, you can put me on the paid staff. So progress comes slowly, and I know that people of your age tend to be impatient, that things don't change fast enough, but what an enormous change has occurred in my lifetime.
I think mine was more the product of ignorance and the good fortune of having trailblazers like Justice Ginsburg leading the way before me. And that was, I'm from a family that did not have a lawyer in it, and so I had no idea what I was doing when I went to law school. And I really, I discovered appellate litigation because I worked one summer in a firm that had a fellow in a guy in it who used to be in the Solicitor General's office, a wonderful man, and he brought someone from the Solicitor General's to talk to us at lunch over the summer. And I thought, what a cool job. I want that job. And it actually hadn't occurred to me that one couldn't or shouldn't do it because of gender. I guess because I was growing up, we now had, at least at that point, Justice O'Connor on the Supreme Court. And so I just sort of kept trying and applying to get into an appellate career at the Justice Department, and then no one actually told me you're not supposed to apply to the Solicitor General's office unless you're coming from a law firm, and so I did. And I mean, it helped that I had worked for a gentleman who'd been in the Solicitor General's office, so I had someone who was gracious enough to recommend me, but I think, I look back now and I think if someone told me there were all these barriers, I wonder what would have happened. So you should actually cover your ears during this panel. If there are no barriers, just go do what you want to do and fight for it, and that's that's got to be at least a big part of the solution.
I mean, I had a professor in law school, two professors, one male, one female, who kind of took me aside and adopted me, and I worked for one of them over the summer. She left the law school and became the head of the appeals bureau at the Brooklyn DA's office, and so I went and spent part of a summer there, and I spent all the rest of my summers at the NAACP Legal Defense Fund. And then at the Legal Defense Fund, it was one of the few places when I went into practice where the staff was half male and half female. It was also half black and about half white. And they had a view that if young lawyers worked on a case, they should get to keep it. And so when the court granted certiorari in this case where I had filed the complaint, there was never any question that I would get to argue the case. And the person who second seated me had worked on 30 or 35 Supreme Court cases during his career there, but he wasn't going to take over the case as long as I wanted to do it. And so I feel very lucky about that.
I just say I think we're actually getting to a point where we may be self-defeating.
It's smarter to be lucky than it's lucky to be smart, right?
Because a lot of the opportunities have been from people who went to places where they had opportunities. You got a case, and then you just kept it all the way through, and that's how they got the opportunity to argue in courts of appeals or state Supreme Courts or the U.S. Supreme Court. And what we've seen, I think, in the last 10 years, Richard Lazarus is the expert, is the development of a specialized Supreme Court bar where people actually don't have that opportunity as often because there are now people saying you need to have a specialist handle your case in the Supreme Court. And unfortunately, I'm one of those people, and now I'm wondering if I'm going to be defeating one of the very purposes I would hope to promote in life, if that really is one of the channels for people to get their cases. And so I think it's something, certainly, to the extent the specialized bar is developing, we have to be particularly and acutely conscious of ensuring that those opportunities remain, and when people pick those specialists, they are picking a diverse group of specialists.
Well, maybe we can move into talking about sort of where we are now. We do have the specialized bar. It is a new phenomenon. It's changing the nature of Supreme Court practice in all kinds of ways. And maybe we can, and Patty, you can follow up on this a little bit, sort of, so where are we today? And Justice Ginsburg points out that wherever we are, exactly, we've made a huge amount of progress in what is really, relatively speaking, a kind of short amount of time. So where we are now is better than we were before. But how is this shaking out for women? Are women able to make these practices work? Is it happening for women in the Supreme Court bar?
Well, I certainly think that certainly within the Solicitor General's office, we now have our first female Solicitor General in Elena Kagan, who was appointed by President Obama a little over a year ago. And that's an enormous stride. Because not only is it another woman appearing before the Supreme Court, but it is in such a high-profile leadership position for the Supreme Court, for the appellate bar, for lawyers generally. So I think that, I hope, will have a profound influence on inspiring women to look at this as a potential career path and an opportunity And so I think that's something to be celebrated. And we have a lot more women in the Solicitor General's office. It still has never gotten anywhere near the halfway percentage point, but it has gotten, between a quarter and a third, and has stayed there for a while, but hopefully that will improve. But at least that's more, and that is such a source of, and that is the prime source of Supreme Court arguments every year, is to be in the Solicitor General's office. We see some women from federal public defenders' offices. Now that may be some of you have your case when you try it and you keep it all the way up, so we need them to keep that to keep that viewpoint. What I'm wondering, though, is you've seen a lot of states. You don't see as many women representing states, and so what needs to be done to diversify the practice within states, and in particular because a lot of states are developing their own Solicitor General practices, so they're actually making Supreme Court and appellate work and expertise within the state government. But it seems to me, and forgive me if I'm wrong, I'm not aware of a female state Solicitor General.
Barbara Underwood.
Barbara Underwood, forgive me. Yeah. Oh my gosh, my former colleague. Other than Barbara Underwood in New York,
right.
I'm not aware of others. And bless her soul for doing that.
We have some states with women as attorneys general.
Attorneys general, yes.
Lisa Madigan in Chicago, and in public offices, it's not just the states, Patty, it's the municipalities. I'm thinking particularly of Chicago, but I don't know if you've seen Benna Solomon.
Yes, exactly.
She's excellent.
Yes, yes.
She's a real tiger.
Yes. And government presumably will still be a decent source for this, but to the extent there's getting more specialization even within state governments, we need to keep an eye on that. And I think the big question is what happens with private industry business cases in the Supreme Court. Now, Maureen Mahoney had done a fantastic job developing a private Supreme Court practice at Latham and Watkins. She is now, I guess, announced her semi-retirement, or I think she's now teaching some here at Georgetown. And I think we're sort of in a transition period. And obviously the hope is, my personal hope, but the hope generally is that we will be able to expand the opportunities for women to be hired by business clients for business cases in the Supreme Court. But that is, I'm confident, statistically the lowest percentage of women appearing before the Supreme Court. That is the new hurdle to be overcome. And like I said, Maureen Mahoney is to be congratulated for moving the ball on that.
But I'm very optimistic about that. As you increase the number of women in the SG's office, and I'm thinking of you and Deanne Maynard, formerly Beth Brinkman, a number of women from that office go on and into private practice and get cases and argue them. And so I think, that SG's office credential and experience is what gives you the gravitas to then say to a private client, let me have that case and argue it. And as the number of women who go through the SG's office and get that credential, there are going to be more of those women moving to private practices, and there are going to be more of those women getting arguments in private practice. So we're filling up the pipeline, and we're going to get. And the other area, and I have to say, I talked to Caitlin Halligan this morning, who was the Solicitor General in New York before Barbara Underwood, and she went for a while and had a private practice, a Supreme Court practice at Weill. So I think that credential that you get either as a state SG or as a woman in the Federal Solicitor General's office can be the start of building a private practice. It's probably a little late for me, but they're coming, and I'm very optimistic that we'll get our share.
Well, and the other big factor is getting women in general counsel's offices at these companies around the country, because that can be a helpful factor in having someone who obviously believes that women can handle big cases, big decision making. And I know, again, the statistics on that are not where we all want them to be, but they certainly are much better than they were 10 or 20 years ago. And I know that a lot of general counsel's offices have been putting pressure on law firms to diversify all their litigation, all their practices, including, notwithstanding, no exception, appellate litigation practices and appellate practices.
Mm-hmm. Pam, can you speak at all to the picture with the Supreme Court clinics? Because another recent development, very recent really, Stanford was the first, but since Stanford, a bunch of other law schools have started Supreme Court clinics, so are becoming very active now in Supreme Court practice. And how does that look in terms of participation of women?
Well, some of the clinics have female instructors, and the Mars has too. Me and Amy Howe, who is here. I think the one that just started at Penn, Amy Wax, is going to be one of the instructors in that clinic. You were in the Harvard clinic. But a number of the clinics don't actually have female instructors, and if they don't have female instructors, they're not going to have a woman arguing the case because the Supreme Court, for obvious reasons, does not have a student practice rule. Students to practice, although I'm sure that many of our students would do a better job than many of the lawyers that you've seen. That being said, I think the interesting thing, and Patty alluded to this a little bit, is how difficult I think it is for women to do some of the business development stuff that men do. I think there is it's not that all men have this quality, but I think that most of the people who have this quality are male, of just feeling the comfort of cold calling somebody who has a case that was decided in the Court of Appeals or in a state Supreme Court and saying, you don't know me, you might want to argue a case in the Supreme Court, but I want to take your case from you. And I think that's something that men are just better at. It's not all men are better at it, but most of the people who are really good at it are male. And I'm not sure if it comes from starting in junior high school with going up to people they don't know and saying, will you dance with me? Or whether it starts with something else. But that, for me, has been the hardest part of the practice. That is, I have every confidence if somebody asks me to write a brief in their case, I'll do a good job. And if somebody asks me to do oral argument in a case, I'll do a good job. But I find it very hard to call somebody up and say, you ought to do this. And so in recent years, there have been a number of these, what you might call beauty contests, where a case is, the Supreme Court takes a case, and then the lawyers think we ought to go out there and look for a new lawyer to argue our case. And I've been in a couple of them, and I find myself saying when the lawyer says to me, tell me about what you do in the case, well, here's my approach to the case and everything. And then they'll say, and we're also talking to X and Y, and they'll name men who've argued a lot of cases at the Supreme Court. And I'll always say, they're very good too, and they'll do a great job for you. And I wonder whether they say, when somebody does it, you could pick me or you could pick her. I will tell you one story from quite a few years ago, which is this was in the early 1990s. There was a civil rights case up at the Supreme Court, and there were two respondents in the case, and they couldn't agree on who would argue the case. And at that point, the Supreme Court clerk's office still would flip a coin. Now I think they just pistol whip the lawyers into coming up with somebody who will argue the case. But the two parties said, well, let's try and figure out who could argue the case. And the two parties and the civil rights lawyers who had been involved in the cases below agreed that I might be a good compromise. And so they said to the lawyer at a leading New York law firm who was counsel of record doing the case pro bono, well, we've kind of agreed on Pam Karlan to argue the case. And he said, huh? And then he paused. He said, I am not stepping aside for some junior woman. At which point they decided to flip a coin. And since our side won, our side then decided to keep with the lawyer who had argued the case from the district court on up, because that was our practice, right? I was a compromise candidate. I don't think there's a woman who would say, I'm not letting some guy argue my case in quite the same way. And so I do think there is a difference in women's comfort with self-promotion and in their comfort with kind of cold calling kinds of self-promotion that makes it hard. I don't know. I mean, whether you guys find it easy to call up people you've never met and say, you don't know me, give me your case.
I can't do it, but I am hoping that you younger women can do it. But I can't do it, and I decline to change my personality to do that. In fact, the one case that I argued 2 years ago, I had the state call me and say, we want you because you haven't been bugging us. So I'd like to think that my personality also can get an argument by not bugging the person.
Well, actually, I mean, I think you're 100% right, Pam, but I mean, if the whole point of getting here is that we turn into men, what's the point? Right? And so, isn't the goal, and this is, I'm sure my partner is covering his ears because the business development is going down the drain. Is there another way to get cases without screaming, I'm the best. Give it to me. They're all trash. Not that the men actually took that abruptly, but is there a way? I actually was mentioning to someone the other day because Virginia told me her story. She got the case because I said she was nice. And I said, and I remember I told someone, you can. I have a friend who got a case once because she was nicer than the other people. And were those males?
Yes.
So you didn't even have to have a female in the general counsel's office or in the government's office to do it. How do we walk that fine line between doing just enough to get the credibility, to get the experience, to make the practices live, and to make it a viable career for women without crossing the line of turning into the men? And that, I think, is the hardest problem, and it's one I struggle with all the time, and I'm hoping someone on this panel will give me an answer.
And it's also a little bit of a difference between your willingness to write a brief and your willingness and your ability to do an argument. That is, I get asked to write briefs all the time, and I have no compunction about calling somebody up and saying, I'd love to work on your case and write your brief. What I find hard to do is that last little, there's this precious thing, the argument, give it to me. And that's the hard part. That's the hard part of it. That is, I find like going out and rainmaking on amicus work, I find it super easy because there you're offering completely to do something for somebody else. It's completely selfless in that way. But when you're asking for their argument, I think that's where the kind of weird currency comes into the process.
And it's ironic, too, because I remember my father once came to talk to the summer lawyers at Migrant Legal Action Program where I was working, and they asked him for 90 minutes about oral arguments. And he said at the end, I can't believe none of you asked me a single question about the brief. 98% of a case is decided, cases are decided on the brief. And, if you want to be, add real value and be the real contributor in a case, you formulate the legal strategy and you write the brief. That's where the real action is, he said. But it's not what's sexy, right? It's is the person standing up there and giving the argument, is the person in the spotlight. But I submit to you that you can do as much to move the law by crafting a persuasive brief and submitting it. Now, it's my bias because I'm not willing to go out and say, give me your argument.
I would back that up 100%. The oral argument is a show. It's a nice show. It's fleeting. What stays with the court will start with the brief. The brief will be there in chambers when the argument is over. The written part of the appellate process, and this goes for courts of appeals as well as the Supreme Court, is ever so much more important than the half hour aside in court. And it helps, if you've been the architect of the brief, I think you have an advantage over someone who's just coming in to make the oral argument. So there is an advantage to having the brief writer present the case to the court. But I hope clients appreciate that what really counts is the brief.
Although the irony is that when clients are trying to decide whom to choose for a case, the question they ask, the one Pam even mentioned, is how many arguments have you done, not how many Supreme Court briefs have you written. And if it's, I don't know whether it is the public face of the case, it is what the press tends to cover. It's sort of the meeting point of I think it's a meeting point of the justices and the lawyers for the first time coming together. It's that first interaction of them in the decisional process. So it's not entirely unfair, but it is ironic that the focus is so much on the arguments.
Well, and one way you can see this, which is I think really interesting, is for those of us who litigate a lot at the Supreme Court, Virginia has been a major figure in terms of the briefs she's written, and everybody understands what excellent briefs they are. And you just heard a discussion of the amazing brief she did for Major General Becton and the like in the Supreme Court. If you read the oral argument transcript of the Supreme Court oral argument, you will see it repeatedly referred to as the Carter-Phillips brief. And the reason it's referred to as the Carter-Phillips brief is a convention that law firms have, which is when they file a brief, you list the people who are connected to the brief in order of seniority or hierarchy, I guess, within the firm in some way.
And I want to give Carter credit here. He said, you'd be counsel of record, so you get the credit for the brief.
He tried.
He tried.
Yeah, every time I've dealt with him, he's wonderful. But the justices themselves, who know that the brief counts for the most, and the like, still refer to it as the Carter Phillips brief because he's the person from Sidley who argues the most.
I thought of it as the brief for the military.
Well, I feel like we've already started to talk around some of this, but I wonder if we can sort of just focus for a minute on, in total agreement that the brief is the most important part, and also since I've briefed more cases than I've argued, I'm very invested in believing that. But there's something about the public role played by women lawyers when they argue before the court that I do think it's a shame that they are so underrepresented in that role, if only because of the message it conveys about what's this court about, what is this profession about, what is this role about. And the numbers are low. They really are. They're not representative of women in the population, women practicing as lawyers, even just a rough sense of the best lawyers I know. Far more than 15% of them are women. So why do we think this is? What are some of the obstacles to fuller participation by women in what is, a discrete role, but still an important role?
Do you have the statistics for women law clerks on the court?
I don't. I was going to ask you what your impression is of that these days.
And I think it's not much different, is it?
I don't think, my rough sense is no, that it's well under 50%. When I clerked on the court, I remember we decided we would have sort of a women's lunch group. And some people thought this was very controversial because it was exclusive. And my view was that as long as we could meet at a restaurant without making a reservation, because there were only 5 of us, this really couldn't possibly be that controversial. It's not like we were excluding other people. It was a very low number when I was clerking, under 10. And so, I think there's some thought that may be part of.
I was thinking about this when I was preparing, and I pulled out a training I do for young women associates called 10 Things I Wish I'd Known, when I started out as a female associate. And I looked through the list of 10 things. I brought it with me if anyone wants to look at it when I'm done. None of them are things that you would say to male associates. So I'm going to advance the controversial proposition, for example, that you don't have to tell male associates, don't start your answer by saying, I'm not sure this is right, maybe this is wrong, I could be mistaken, but here's what I think the answer is. I say, don't ever start your answers that way. It's just covering yourself, and it's to make sure no one gets mad at you. It's a very common female defense mechanism. Don't use it. Now, if you have to say that to young women associates at a law firm today, which you do, doesn't that give you a little hint about why women might have a harder time of breaking into and becoming equal representatives in this very public process of Supreme Court argument? To me, that, and there are 10 similar tips that you give that are very gender specific. Again, I don't want to overgeneralize. Plenty of women can do it. But there is a general difference, I think, in how women approach their work.
Well, I do think, and I was actually talking with Jeff Fisher, who works on the Stanford clinic with Pam, and I know when I first started working with Tom, was that there was, and you can speak to this more than me, but a hard time just getting female students to enroll in equivalent number, in appropriate numbers, to enroll in the clinic. So even at the law school level, there seemed to be a lot of self-selection out of this practice stream, and I don't know whether the statistics, how they correlated to the percentage on law review, and the percent that end up clerking, and all of that. But there's, how much of it is self-selection? And if the self-selection is free choice, amen to it. If it's self-selection because that doesn't seem like a viable career path for me, then that's a problem that has to be dealt with. And I think it just continues throughout careers. As equal as we all are, the women still have the babies. And the difficulties of juggling working parents and working motherhood, raising children. I've brought my daughter here with me. This is how I do working motherhood. is an enormous challenge, and I think it is a hard one, and I think it is something, and people have to make their own choices. I'm a big believer in find the balance that is right for you and do it, but how much, again, of that changes people's career paths as they're going forward.
That can't be the answer in appellate law. I mean, my mother used to say about appellate law, stop whining, you're the dermatologist of the law. It's much more manageable practice, and I know even I don't have a full-time appellate practice, I have clients that have normal problems, but appellate practice is something you can manage, is something you can do part-time much more easily. So 19 years, I've been working 60%. So it can't, it's easier in appellate practice than in a regular litigation practice to balance work and motherhood. So that can't be the answer of why women aren't enrolling in equal numbers.
I never disagree with Virginia. I'm sorry. But can I just say, I think a lot of it depends on environments, because we said Solicitor General's office is the place to get experience. That maybe they will get to the point where they will have a better developed opportunity for part-time opportunities there. I think Lisa Blatt had done it for a little while, but when I went there was no part-time option, and that is a job that is a 90-hour-a-week job. And I remember when I was there, and again, thank goodness, no one had told me, and I was too stupid to know that when I had my first child. There had actually been, Nina Pillard, who teaches here, had just had a child, and there have been people like Harry Shapiro who'd raised children, so what is the issue? But I remember when I was pregnant my second time with my daughter, a person who will remain nameless coming to my office saying, no one stays here with two young children. Harry Shapiro's children are a little bit older. No one does that. And thankfully I just said, well, I'm going to, and did. But there were still messages, and there are a lot of places where it's very hard. You have to, if you really want to have the high profile, get the arguments, fight for the clients, fight for the business, and juggle that with family. It is not easy, and it may not be the right choice for an awful lot of people, but it is, I think, part of the issue.
I was surprised to hear that the enrollment in clinics is lower for women, because in ancient days when I was at Columbia, I was running a gender discrimination clinic. Harriet Rabb was running a Title VII clinic, and there were a disproportionate number of women signing up for those clinics. I remember one exercise in particular. It was the school had a simulated constitutional litigation seminar, and I had a seminar that was working on whatever I was working on. At that time, the ACLU was bringing cases to establish that women have the same obligation as well as right to serve on juries as men. The Constitutional Litigation Clinic did a moot court on that question, and my students, who were working on a case called Healy against Edwards that did go to the Supreme Court, they were ever so much better than in the simulated group, because this was a live case. It really mattered. And some of Harriet Rabb's Title VII cases, huge cases against AT&T, against the New York Times, women were very enthusiastic about becoming part of those clinics.
Well, that's still true. That is, if you look at clinical enrollment at Stanford, for example, we have a number of clinics that are disproportionately female. They're direct services clinics. So the community law clinic is very heavily women. The youth and education law clinic has had a couple of semesters where it's completely female. But we've had trouble in the Supreme Court clinic getting women in. And I think this is a point at which something Virginia was saying a couple of minutes ago plays in, which is, if you're thinking about an appellate practice generally, there is no better kind of practice to balance with whatever the other things in your life you want to balance it with. So I don't have kids, so it's not a balance with that, but it's a balance with my teaching and my scholarship and my family and stuff more generally. You know, I can work, you can work on appellate briefs. First of all, you almost always know when they're going to be due long ahead of time. You can work at them at nights and weekends. You can work at them at home. You can, it's amazing the places now with the internet revolution and everything, it's amazing the places you can work on a brief and the times of day you can do it. And so it's a fantastic practice. And I think if you look at, for example, government offices that do appeals, not the SG's office, but, for example, the Brooklyn District Attorney's Office, where I spent some time, or you look at the Legal Defense Fund, or women are quite well represented in that practice. Because that practice, the cases come to you. And so it doesn't require you to be a business getter. It just requires you to be a business doer. And this is an incredibly wonderful kind of work to do. I mean, it's endlessly interesting. If you like writing and research, there's nothing better than it. But I think the Supreme Court practice has this additional problem because of the scarcity of the argument opportunities and the fact that the Supreme Court bar has become ever increasingly, it's become much more oligopolized over the last decade and a half or so. So that it now really isn't the case that you see high-ticket cases or even remotely interesting cases where somebody who hasn't argued a case before gets the case once it's at the Supreme Court. The one place where you do see a difference there is a case where, for example, Justice Ginsburg was quite instrumental, which is she gave somebody an important oral argument at the Supreme Court in a case for the first time recently, which is a case called Reed Elsevier against Muchnick, which is occasionally the Supreme Court appoints amici to argue in support of the judgment below, and the justice from that circuit is responsible, I think, for picking somebody to argue the case, and then the court asks the person to do it, and that was Debbie Merritt. But there aren't a lot of other opportunities to pick up your first case. And without your first case, it's very hard to have a second case, because it wouldn't be a second case without a first case.
There was, just before Debbie Merritt's argument, there was a former Stevens clerk. It was a case from the Seventh Circuit also. These were cases where the parties agreed on whatever was the threshold procedural point. And so the court needed to have someone defend the Court of Appeals. And that's how
I think it's Amanda Leiter.
And
yeah,
Amanda
Leiter.
yes,
yeah.
yes. And I think I wrote the opinion in her case, and I said something in the text about how well she had performed, even though it was an impossible case in the sense that with both parties agreeing that the Court of Appeals was wrong.
The family work balance issue, I think, is so interesting because, as Virginia says, appellate law ought to lend itself. Appellate law really ought to lend itself to that. Although, I will say, there are more emergencies than you would think. There are more tight time frames. You would think people give up the brief 2 days before it's due. Surprise, now you're doing it. And we did, don't ever say this, we once had a summer associate in my practice at O'Melveny who came to me at the end of the summer and said, you know, this has been a tough summer. It turns out I'm really very bad with deadlines, so I think I'd like to be in the appellate practice. Great. So, you know, one should not exaggerate really just how easy it is. But what I sometimes worry about is that although functionally speaking it really ought to be doable, there is this odd intersection when you get to the Supreme Court point. I think there are still people out there who think, well, she works part-time. She's not, you know, really a star lawyer. That's just inconsistent. She's not that committed to her career. I don't want a lawyer who's not that committed to her career. I don't want someone who works part-time to argue my Supreme Court case. I mean, I'm good with it in other areas, but this is a Supreme Court. I have a different vision of what a Supreme Court oral advocate looks like, and she doesn't look to me like someone who works part-time. She looks to me like someone who's more committed to my case. And I do think that even though it may be functionally very doable, there's still a bit of a problem in the way people conceptualize, you know, the person you send up to argue at the Supreme Court and whether that matches up with someone who is working part-time or just seems very engaged, whether they're working part-time or not, in family matters.
Or whether it's even a she that they visualize, which is an issue. But one, it would be great to get even more female justices on the Supreme Court. I think at some point that becomes an important part of the dynamic, and it's been vital that Justice Ginsburg and before her Justice O'Connor were there, I think that's been vital for so many law students, lawyers, businesses, clients. What I don't know is what the percentage now of female judges on the courts of appeals is. I think that's an important part of the picture because most companies, that's the end of the road for them. And they need to see more, when they see more diversity on the bench, and we're obviously leaving out of here the entire question, which I think you mentioned at the beginning, of racial diversity and ethnic diversity, which is a whole other problem and issue to deal with. But the more, it's all a question, I suppose, of glacial change, and as Justice Ginsburg said early on, it's enormous change from her vantage point. I think the problem is that as you get more change, there's a snowballing desire for more rapid change, and I think that's where we encounter some of the frustration, because once you break through the door, you start going, why don't we have it all? Why is there any barrier left?
And appellate practice is also these short shots. And, I have a client, the Major League Baseball Players Association, that's been my client for 25 years. If they have a matter that goes to the Supreme Court, they don't even think about using anyone else. I have a relationship with them. They don't care that I work part-time, that I've worked part-time for 18 years. They know that when they've had a problem, a strike or whatever, I've been there for them. So the fact that I have a long-term relationship would get me business in those cases, and they've taken a couple of cases up. But in most appellate cases, you don't have a relationship. You are, going in to get a short-term event with someone. And so it doesn't play to one thing which I consider really a strength, I hope for myself and for many women, which is this ability to build a relationship where someone has confidence in you and know that you'll be there for them even if you, are a part-time lawyer, as I have been for many years. So there's another, sort of aspect of what you do well that you have to take into account. The appellate relationships are flings.
One of the things that makes me optimistic is to look outside the United States and see how the law practice, the people who are sitting on the bench, how that is changing. We had an exchange, it was last week, with the Supreme Court of Canada. And that Supreme Court sent a delegation, their chief, who was a woman, and 3 associate justices, only one of whom was a man. And, you think that people would say, my goodness, isn't that strange? Nobody commented on it at all. Nobody noticed that the delegation from Canada was 3 women and 1 man. I think as the numbers grow, so now we're 2, but I think we will be 3 and 4, and maybe more. I think that does make a difference. And let me say in that regard, putting women on the bench, the president who deserves enormous credit is Jimmy Carter, because when he became president, there were none, or almost none. There was 1 woman on a U.S. Court of Appeals in the entire country, Shirley Hufstadler. Carter made her the first ever Secretary of Education, and then there were none. But he was determined to, as he put it, change the complexion of the U.S. judiciary by selecting members of minority groups and women in numbers. And although he was our president only 4 years, by the end of that 4 years, there was an enormous change in the complexion of the U.S. judiciary, and no president ever went back to the way it once was. But that was a person who was determined to make a change and looked for people where other presidents, it looked in places where other presidents hadn't looked before.
I do want to make sure we have time for questions from the audience, but I wonder if our panelists would be prepared to just offer any last words of advice for women students who may be considering a career in the Supreme Court or appellate practice more generally. What to expect and how to prepare. Virginia, do you want to?
Sure. Clerk, take federal courts, because I think that an ability to think across areas of law is one of the most sort of critical skills for an appellate lawyer, to think about standing, mootness, ripeness, finality, all those kind of cross-cutting areas. I think if you can link different areas of law and think creatively, you're much more likely to be a better appellate lawyer. So it's worth even starting to think about that in law school in terms of finding a great professor of federal courts and taking a great federal courts class. I think is critical. Class certification, all those kind of areas that might cut across different subjects. And if you have a great mentor in law school, talk to that person. And when you have summer jobs, talk to people who are in practice areas that you like about how they got where they did. Form friendships and relationships like that. But I don't think clerking and working for the government, both in state SG offices and in the Department of Justice, I think are the best ways to an appellate practice.
I agree with a lot of that. I guess, born of my ignorance, is, if you decide it's something you want, put your head down and go for it. Don't let people tell you that's not the rules, that's not the right way. I didn't clerk on the Supreme Court. I went to the government, which wasn't how you're supposed to go to the Solicitor General's office. But I just sort of kept knocking. And you do have to develop relationships. You have to work really hard and have the type of work that people will be willing to stand behind and endorse. Look for mentors, both female and male. I mean, there are plenty of, thank goodness there are plenty of males, even before, who were very supportive of women. So don't assume you have to have just a female mentor to push you in this process. Get as many mentors as you can who will help back you and push you. But if you decide this is what you want, or whatever else it is that you want, I think it changes some by luck, some by right relationships, and a lot by just people saying that's what I want and pushing and insisting upon it.
Yeah, if what you want to be is an appellate lawyer, the thing you should do in law school is spend as much time as you can on persuasive legal writing, because that is what briefing is. It's persuasive legal writing. So learn how to do the persuasive legal writing. Work for an organization when you graduate, which may well turn out to be either the government, state and local governments are particularly good at this, or a nonprofit, that will let you take on appellate work early in your career. Lots of the courts of appeals have pro bono programs. The Ninth Circuits, for example, will not only give you a case to brief, but they will guarantee you, if you take a case out of their pro bono project, that you'll get oral argument time on the case. And start building a track record, because that track record is really important. So in addition to the kind of thing that Virginia and Patty were talking about, which is the clerk and work, there's a kind of third one that rhymes, which is don't be a jerk. Because a lot of how you will get clients and get referrals and the like is from the people you already know and the people you're working with now. The reputation you get early on in your career for doing a good job on cases will follow you through your cases. And then if you're lucky enough and a Supreme Court case comes along, you'll get that. But even if you don't, I mean, I think my career, it's been great doing Supreme Court cases, but I think the appellate work I did more generally, I would have been perfectly satisfied with that as a career, and I wouldn't spend my whole life saying, if I never get another Supreme Court argument, I'll wish that I'd been struck by a train in 51 because I have nothing left to live for.
I think we should pick up on a point that Patty introduced, and we didn't talk enough about it. It is, there are no closed doors for women. But what happens when the baby comes? And I must say that in my own life, the luckiest thing that I ever did was to pick my life's partner. And one of my classmates in college said to me, you know, Marty, my husband, is so confident in his own ability that he will never regard you as any kind of threat. On the contrary, he will be your best booster because he decided that we would share our lives together. So at different times, the balance has been different ways. When Marty was a young lawyer climbing up the ladder to make partner in Weil, Gotshal & Manges, I remember saying to him about my son, this child is 4 years old and you haven't yet taken him to the park. Then I got my first good job in D.C. when Jimmy Carter appointed me to the Court of Appeals for the D.C. Circuit. Everyone assumed that I was commuting between New York and D.C. Marty transferred from Columbia to Georgetown, and there wasn't any question that that's the way we would live. He has become a super chef. I haven't made a meal in 30 years. So the support that I have had from him, because he believed that my work originally was as important, but now more important than it is. But it takes that kind of strong man, or whoever your partner is, someone who never regards you as threatening, but somebody who is really good and who should be helped along her way.
Certainly can't improve on that. If you all have questions, if you can just come to the microphones, we'd be happy to sort of expand this conversation a little.
Pardon me for taking the first question. I actually, on a similar note, I was wondering, because we were talking about it before, you were talking about it before, I was wondering why aggressiveness doesn't necessarily have to be the domain of men. As I understand it, in this society, to get to the top of any career, you have to be fairly aggressive. And the law, litigation particularly, is very competitive, which I think requires a certain amount of aggressiveness. And I'll point out actually that in our Blue Dream Moot Court finals here that we had earlier this term, 3 out of the 4 finalists were women, and I can't imagine them being incapable of being pretty aggressive. Obviously, they're very competitive. They were up here with a similar number of people, watching them argue in front of 4 justices. So I just wanted to. There seemed to be a little bit about a debate whether or not being aggressive was either required or whether or not women should be or could be aggressive. Any responses? Thanks.
Well, I'll just make one, which is, and maybe Justice Ginsburg had the same experience I did, which is I didn't feel in my academic career that I needed to be interpersonally aggressive at all. Obviously I have to write in an assertive way and the like, but, I didn't have to call up places to give me offers. I put the thing in the mail and some law review takes it, and it doesn't require the same kind of selling of myself in which I feel like I'm kind of personally making a competitive claim that business development does. I think the Academy, and that's one reason why maybe I was attracted to the Academy, is I felt I could do the work and I would get the reward from doing the work without ever having to say me while doing it.
The work speaks for itself. That's what we're taught to think.
And
just do good work and it will speak for itself.
No, right. But the getting people to say, and you should argue my case, that doesn't speak for itself.
Right.
I think.
Sorry, go ahead.
No. Speaking of the first Assistant Solicitor General, Harriet Shapiro.
I just wanted to add 2 things. One is to absolutely second Justice Ginsburg's last point, that what makes it work is to have a husband that is absolutely, totally supportive. That was proved for us when we both had Supreme Court arguments in the same week, and we survived it. The other thing that I wanted to emphasize, it's been mentioned, but if you want, I certainly agree that the Solicitor General's office is the place to go if you're interested in Supreme Court practice. But I also want to add, I hated oral arguments. I really hated them. Briefing was great fun. The scope of the issues you get, the variety, and they're all cutting edge. And brief writing is lots of fun. And if you don't think you're going to like oral arguments, don't let that stop you. The Solicitor General's office is a great place to be.
I completely agree with this, but I do have to point out that I wonder if this were a male panel, how many people would say that the most important thing to their successful appellate practice was their supportive spouse.
I'm just going to say, I think on the, and I mean, Harriet is just quite a leader in the Supreme Court bar herself. But I think for me, I love oral argument, except for the 2 days beforehand and the day afterwards. Otherwise, I love oral argument. And I like the brief writing, which is where I channel my, I don't know if aggressiveness is quite the word, but my, I mean, if you want to use that word, that's where I channel it. And that's where I put, my fight and my vigorous, advocacy and my excitement about fighting for and defending my client. And I channel it into there. And I think the question is not whether you have to be aggressive or a zealous advocate in that sense. It seems to me that's where it should be, right? That's the job. And the question is, it's a challenge for women, I think it is for me, is that is not my interpersonal relationship with people outside writing briefs and outside the courtroom. And whereas maybe for a lot of men it is to keep that level up. And so do we have to become like that, or will the world come to accept women as channeling where they do this zealous performance, but still being able to have, like Virginia did, a nice conversation with a client who then wants to hire you because you are not doing the pushy, aggressive selling that other
But
people
don't
are.
let Patty mooch you.
Here's the thing, the difference is I don't have a problem being aggressive on behalf of my client.
Someone else.
I have a
Right.
problem being
Channeling it.
aggressive on behalf of myself.
Yeah.
And I think it's the thinking of yourself as, you don't want one of the self-help books, I'm my own best friend. Because if you're your own best friend, that's a sad sign. But you do want to think, I am my own client when I'm out there doing business development. I actually think it would be much easier for me to persuade somebody to hire Patty by cold calling them and saying, you ought to hire Patty to be your lawyer, than it would be for me to call them up and say, you ought to hire me. And it's not just because she'd be better at it. It's
Let's
also
make a deal, Pam.
Yeah, let me just start doing this. This is a solution. We've got it. We've got it.
For the person to our left.
I must say that there's a real generational difference in this regard of the question is aggressive, putting yourself forward. I am far from an aggressive person, but I went to law school with 9 women in an entering class of 500 odd. There were 2 of us in each section, and we felt that if we were called on in class, we had to get it right, because if we didn't, we would be failing not just for ourselves, but the professor would say, that's what women law students are like. So we were accustomed to being in the limelight. We took it as kind of our responsibility to teach our male classmates and teachers that women had everything it takes to be successful in the law business. So people that you would not describe as aggressive, in our law school classes, we felt that obligation to put ourselves forward and show how good we were.
Hi. First of all, I wanted to thank you all so much for coming and speaking with us. It's a very unique experience, and I appreciate your time. I did have a question, because I know, Ms. Seitz, you had addressed the issue of dealing with these masculine traits and whether you feel like you have to adopt them for yourself in order to be successful in this field. I wonder if the flip side works at all, if you feel that there have been traditionally feminine traits that have aided you in this, or if you feel that there's a future in maybe not being so aggressive in this profession, or any benefits you might have gotten from just being a woman instead of having to deal with grappling with a masculine.
Wow. Yes, I have definitely had benefits, and I do think, I have had a long-term relationship with my favorite client of 20 years, and I think that has I built that relationship personally, with sharing about children, sharing about a variety of family things. And as my husband said, you put more personal things in a cover letter than I would say to my best friend. So I'm willing to get to know the person I'm working with, and I do think that's been a benefit. But as I said, I think, appellate work can be kind of a one-night stand, so it doesn't necessarily carry over as well. But yes, sure, I want to be who I am.
I think I have benefited in many ways from working part-time at a law firm. It forced me to be an excellent delegator. It forced me to make an investment in junior lawyers, spend a lot of time teaching them at the front end because I was going to need their time because I couldn't be there all the time. And as a result, I ended up with amazing associates who were incredibly loyal to me. We had a very, very good working relationship, and that was forced on me by the fact that I worked part-time. And many of my colleagues who worked full-time, it was easier for them not to bother putting in the time at the front end, just sort of assume they could do all the work themselves and then be left at the end without much. Without two things, support from junior associates and really just incredibly rewarding and worthwhile mentoring relationships with junior associates that grew out of necessity, the fact that I was working part-time. So I've always thought that for me at least, working part-time, which is a little bit different from being a woman, but there's a close correlation, has had enormous benefits, both personal and the relationships I've developed and professional.
Can I just say that I think one thing, and this is not women in the Supreme Court bar, it's just women in the workplace, generally is, and you all can attest to this better than me, but generationally, we now have, it's not just the woman who wants to take leave after the child is born. Virginia's husband, Roy McLeese, was in our office, and he was the best example of the person who, the male in the office who made raising the children a priority just like women in the office. And, we have, I think, a change generationally in this role and recognition of the balancing work and family, whatever your family unit, but balancing work and family is actually not just a female issue anymore. And maybe that will slowly change things in a way. And I think that is because of the presence of women in the workforce generally, that we're seeing that shift. And as that changes, I think that will hopefully put some more wind in the sails of women in the workplace and in the law profession in particular.
When Sweden, a country that I know a little bit about, introduced parental leave in lieu of maternity leave, someone commented to me, well, only 10% of the leave time is taken by men. If 10%, that's a good beginning. And one of the most attractive law clerk applications I ever got came from a Georgetown graduate. He was going to Georgetown in the evening program, and he was the primary caretaker of 2 then young children. And he said the reason why he elected for the night program here was that his wife had a good job at the World Bank as an economist, and he was the one who was picking the children up at school, going to soccer practice, and the like. He was an excellent law clerk for me twice, once in the Court of Appeals and once in the Supreme Court. But I think more and more you're going to get women on the bench, you're going to look at people like that, and instead of saying, oh my goodness, I wouldn't touch him or her because of the child care. I mean, a number of us now have had law clerks with 2 small children. And the justices who have made that choice have never felt shortchanged because these people are super efficient, and they have a life that gives them a great deal of personal satisfaction.
Yeah, hello. This is a question just based on something that Justice Ginsburg said earlier about President Carter looking in different places for new new lawyers, to appoint to judgeships, and appointing you to the D.C. Circuit. And I was wondering, in a slightly on a related issue, if you thought that the Supreme Court, and courts plural, would benefit from that happening with regards to religion, as it happened with regards to gender. Would the court benefit from more religious diversity, looking in new places that it hasn't looked before?
Well, we're not representative of the United States as far as religion is concerned. We have on the court 6 Catholics, 2 Jews, and only 1 white Anglo-Saxon Protestant. That's unusual in U.S. society. But I don't think that any of us would like to be identified as, say for me, the Jewish justice or the Catholic justice. We happen to have a certain religious heritage, but we should not be chosen for the court, I think, on that basis.
For all of the panelists, but following specifically on a point that Justice Ginsburg made. Justice, you alluded to some of the old days when you were in your law school class and the extra level of pressure that you felt to represent, to some extent, the capabilities of any or all female law students at the time. And I wonder if the panel feels a similar type of pressure or proprietorship or that extra level of representation. And if that's true, to what extent do you impart that to other women who may be coming through the pipeline? Or are we just so successful at this point that you don't think about it at all?
Well, I think about it all the time, and I particularly think about it with respect to part-time, because I have been working part-time for 18 years, and I'm aware of the stigma about part-time, so I like to always say yes. If somebody wants me to do something extra, I never say no, or I try not to use my kids as an excuse not to take on a project. So yes, I think it's not been so much my gender, because there's a critical mass of women in the Sidley and in the other appellate practices that I don't think I have to prove anymore that women can do it. But I certainly have felt a great deal of pressure to prove that part-time can work, so that I don't deprive anyone that follows me of the opportunity to work part-time, because I feel very strongly that it's made my life possible as a mother and a lawyer, and I would hate to give it a bad reputation.
I think we probably all feel that way. I think to the extent that Virginia and Professor Harris, when she was at a Melvin marriage, did that, they have done it so successfully and developed such tremendous reputations that you really, I guess I'm here today, I think you've more than succeeded in doing that, and that will make it easier for other people. And I know I feel very conscious all the time, because one of it is just my own personality. I'm just, I am the insecure one who wants to begin with an apology for asking a question. Thank goodness Justice Stevens does the same thing. He's my hero in that regard. But it comes across better when he does it. It's in part because my nature is to feel like I really have to work 8 times as hard just to get it right, and I'm a perfectionist by nature. But I do know, or I do worry. I can't say that I know. I do worry that people will say, if you don't do it as right, that they'll be wondering if we had. I had a case where I was chosen over a male to handle a case in the Supreme Court. And it was apparently a very controversial decision, and I felt acutely conscious all the time that if I don't come in at my absolute highest level, and then you're just absolutely killing yourself, which is hard with the family life balance. Hard to have balance when you're killing yourself, and that's the fight that I find myself in, is trying to be the absolute best, because that's my nature. It's what I want to do apart from gender, but also because I'm consciousness of that you're concerned that the repercussions of not doing something, not being the absolute best, will affect not just you but others.
I think sometimes the hardest thing, in a way, is the sense that you're never better than the last thing you did. And so it's not even as if, so the pressure is always there that if you screw up this time, no one will ever remember that you ever did anything good before this time. And I think that fear, and the fear that people will think, you've done a terrible job here, it must have been a terrible job at everything you did up until this point, that never goes away. And you never have enough time to do everything, and to do everything well. And so whether it's you know, kids, or it's your scholarship, or it's your family, and at the stage in life that I'm at, you start thinking about your parents, and so you can never be a good enough lawyer, a good enough daughter, a good enough partner, a good enough friend, a good enough scholar simultaneously. And so you're always thinking, what is the thing that today I'm going to do in a half-assed way? So, some of it is just trying to feel that, that you're at least doing them a little bit well all at the time. But it's very hard. I mean, the balance. Virginia and Patty and Pam are talking about balance with kids. Don't think if you decide not to have children that it's going to be all that much easier unless you decide you're only going to do one thing. I think if you decide you're only going to be one thing, if you're smart and you're dedicated, you can do that one thing in an excellent way. But otherwise, you're always going to have this sense that you're shortchanging something. And that pressure will never go away. It will only get worse, actually. I mean, I worry about it more now than I...
Stop!
Well, on that note, they quote something from one of my great heroines. It's a woman who was a Nobel Prize winner in the 1980s, Nobel Prize winner in medicine. Her name is Rita Levi-Montalcini, and she wrote a book called In Praise of Imperfection, and she describes what she means by that title. She takes it from a poem by William Butler Yeats that says, in effect, in life one must choose perfection of the work or of the life. You cannot have both. And she said that she, in her long life, had come to agree with the poet. You cannot achieve perfection of the work and of the life. But, she said, in my imperfect ways, I have lived my life and derived inestimable joy from the things I have done. Therefore, I have come to conclude that imperfection, rather than perfection, is the natural way of humankind.
Wise.
I just wanted to thank you guys all for coming, and I really enjoyed hearing your perspectives. I'm curious to hear your thoughts on why increased female participation in the Supreme Court bar is a good thing. Is this just a question of equality of opportunity, or do you genuinely believe that more women participating in the creation and advancement of law will have some sort of beneficial impact on society and on the law?
Yes, I believe in the inherent value of equal opportunity and equal participation. So yes, I think it's an inherent good. I can't really defend that proposition other than by believing in it. I also find and believe that we bring to bear on the profession. When we practice, our daughters are watching us and all women are watching us, and we set an example and open up opportunities for the generations that come after us. That's a good thing for everyone to think they have a possibility of doing whichever thing they choose to do. So for both of those reasons, yes, I think it's a good thing for people to feel that they have an equal chance at almost everything, not just arguing before the Supreme Court.
Well, and to quote some words from some of the jury cases that you worked on when you were a litigator that were talking about what difference does it make if you have a jury that's all male or all white versus a jury that's of a variety of races, and the court said a flavor gets lost, and you can't quite pinpoint what it is because you don't know exactly where it comes from and the like. And so I think that's true. That is, I don't think that, did I argue the bankruptcy case that I argued differently than Tommy would have argued if he had argued it? Maybe, but I don't think it was like bankruptcy in a different voice. You're asking.
I love that book.
High-pitched, squeaky voice. That gets higher and starts asking questions at the end when it gets high. I don't think it was that so much, but I think over the course of dozens and dozens of cases and dozens of arguments, the fact that people are different from one another in a whole variety of ways will make a difference to the quality of the law. So it's that flavor that'll be lost, but you can't kind of distill it out. It's not like chocolate chip ice cream where the woman is like the chip. It's more a kind of blend of things, and you never know where it's going to be lost from if everybody isn't a full participant in the process.
I'm afraid we're just going to take one more question. I think we've been waiting longer on this side.
Okay. Thank you all for being here. I have a question. I'm curious about the contradiction between the nature of appellate work being well suited for the traditional female and the fact that there's less applicants in the clinic and people in the bar. And I'm wondering if there's another aspect of the appellate litigation that can explain it, and that is that there's no substantive expertise that you have to kind of learn. Well, there is, of course. But there's no substantive expertise in the law. Let me tell you, I believe that you have to be an expert in appellate litigation. But what I mean is you have to have a confidence. There's a skill perhaps in selling it in these beauty contests as knowing a little bit about an area and being able to puff it up as knowing more. Do you know what I mean?
Yeah.
I'm wondering if that's something that plays into the dynamic, or just what your thoughts are on that.
When someone asks me about a career in appellate law, especially young women, I always say, and in addition to this process expertise, develop a substantive expertise or expertise in the workings of a particular sector of the economy, of business, because, first of all, there's a great joy in expertise. And I was a labor lawyer before I was a Supreme Court lawyer, and I still love that someone can call me on the phone with a labor law question. I can answer it without looking at anything. I know the answer usually to their labor law questions. So there's a joy in expertise that I think is extremely valuable, and it's always worth doing that in addition to your Supreme Court. And most Supreme Court practitioners will tell you that they have some substantive expertise. I mean, you're an obvious example with your civil rights expertise. So I don't really think that explains it, because I don't really think I know very many Supreme Court lawyers even who don't have an underlying substantive expertise.
I don't.
You do too.
I don't.
Well, let me say on that the appellate advocate is talking to a generalist bench, and the appellate advocate will learn an enormous amount of this tiny corner of the law. Having gone through that learning process, maybe that person is better equipped to convey it to the court, because the court's going to go through a similar learning process, than someone who really knows the field cold and may be too advanced for the bench. I mean, when I was growing up, I expected I would be a teacher. And in my advocacy, even what I do today, I think that's mostly what I am doing, trying to impart what I know to people who haven't thought about those questions, to take people step by step to where I would like them to go. And as I said, sometimes not coming to it without knowing anything about the particular field can be helpful rather than harmful.
Yeah. I was just actually, thank you, Justice Ginsburg. I want a recording of this for my client pitches, but actually making this exact argument just the other day in a pitch for a case. And I call it my expertise is translation, and that is taking a complicated problem in a specialized area of law and translating it into the language of generalist judges, the legal concepts that they tend to grapple with, and how they are likely to approach the issue. And so it is actually being the intermediary between the specialist. This is what I think I'm a specialist in, is being the intermediary between the specialist in the case and the appellate court. And if you'll give me the liberty of just backing up to the prior question, I want to say one of the reasons, I think gender diversity is important is simply because I think on religious diversity, I don't believe in reincarnation. I think we've got one life here, and everyone should be able to take whatever it is they really, really want to do and be able to do it. And whatever that is, find what you want to do, but you should be able to do it regardless of your gender, your ethnicity, your religion, your race, any of those things. You should be able to do it because it's the right thing, the right way for the world to operate, and it is an enormous waste of human resources when people can't do something simply because of artificial barriers. I want my daughter to be able to be whatever she wants to be, as long as she can support me.
Well, I hope you will all join me in thanking our wonderful panel for coming today.